particularly about, for example, Dr. Riostovas. I requested a 702 hearing.
I'm sorry, would you repeat the name?
Riostovas, Rios dash Tovar. And Mr. Riostovas was one of the state's experts,
You remember that, yes.
and he was testifying via Zoom.
That's correct. He was the only one testifying via Zoom.
Did the judge grant Mr. Shelley's 702? Was Mr. Shelley allowed to take Dr. Riostovas on voir d'art for a Dobert/702 hearing?
No, not a 702 hearing. We were allowed to cross, but not a 702, 705 hearing.
Okay. Was Mr. Shelley allowed to conduct a 702 hearing for Dr. Ross, who was a radiologist and also expert witness?
He was not.
Okay. There was a discussion at some point about an expert witness named Dr. Radinovich.
Mhm.
Do you remember that the state did not have Dr. Radinovich available?
I do remember that, yes.
Do you remember that the state filed a late notice of expert?
I do remember that they gave notice of the assistant, I believe, of the nurse assistant of Dr. Radvanovich.
Yes, her nurse practitioner. And do you remember that the defense filed an objection to the late disclosure of the nurse practitioner's disclosure as an expert?
We did. We filed the objection, yes.
Okay. Do you remember that the court held a short hearing regarding that particular expert, the nurse practitioner, and her late disclosure?
I do remember that, yes.
Okay. Do you remember that during the discussion, the state and the defense agreed to have the nurse practitioner testify despite the late notice, with a caveat that the defense would be allowed to conduct a 702 hearing?
I do remember that, and the conversation was with the prosecutor, Mr. Amdur.
Okay. Now, when the nurse practitioner was asked to testify, do you remember whether or not I tried to conduct a 702 hearing?
We did. We asked for a 702 hearing.
Okay. And the 702 hearing typically is a three-pronged type of hearing. It includes, qualification, reliability, and relevance. And
Yes.
in that hearing, the judge only conducted the first prong. I was only allowed to question the nurse about her qualification.
That's correct. I remember we went extensively through her qualifications, and that was the basis under which she was allowed to testify. I do remember that.
And do you remember that we were not allowed to question her on reliability or relevance, the second and third prong of Dobert? The
judge didn't consider or basically allow those kind of questions. It was just a qualifications issue with her.
All right. Would you say that we were not allowed to conduct a full 702 hearing of that witness?
I would agree with that.
Okay. Now, at some point during the trial, while Mr. Shelley, I was no longer there because I had to leave, you had a discussion with Judge Lizarraga in chamber.
We had multiple conversations in chambers with the judge, and there was a record of it as well.
Okay. And during one of these conversations, that was subsequent to, okay, so let me rephrase. Now the state in chief is over, and the defense is presenting two expert witnesses, which were Dr. Monson and Dr. Galaznik. Do you remember that?
I do remember that.
Okay. Do you remember that whether or not the government had filed a motion requesting 702 or 705 hearing pre-trial?
I don't recall, or I don't remember if they ever filed an actual motion asking for a 702, 705 hearing.
Okay. Do you remember that whether or not they were, okay, so let me strike that. Do you remember the state asking to take either of our experts on 702 for a 702 hearing?
I do remember that, and no, they did not ask for a 702, 705 hearing on our experts.
Okay. Who asked for a 702 hearing on the defense expert?
That was a bit of the confusing thing about the case. The judge was the one who asked for a 702, 705 hearing. At one point, he hinted that it was because we asked for a 702, 705 hearing on our experts. But then he later on he clarified that he was the one who wanted a 702, 705 hearing.
So the judge Sue Sponte decided to conduct 702 or 705 hearing.
That's right. I don't remember the state themselves asking for a 702, 705 hearing on our experts.
Okay. And at the conclusion of this hearing that were conducted outside of the presence of the jury, did the judge allow the defense expert to testify?
The judge did not allow Dr. Munson nor Dr. Galasnik to testify.
Now, subsequent to this hearing, I want to focus now on the in-chamber discussion that the judge conducted with you and Miss Pages.
Yes.
In chamber, they with you, they with Miss Pages, and they with also Judge Lizarraga and the Assistant District Attorney, Mr. Amdur, ADMUR, I believe.
Yes, we were all there.
There was
and there was a record as well.
okay, and there was discussion about at some point about mistrial.
Yes.
Can you tell us how that came about?
So after both Dr. Munson and Dr. Galasnik were not allowed to testify, we went in chambers and we were discussing, and if we had any further witnesses, if we were going to put our client on the stand. And then at one point, the judge brought up that regarding a mistrial, he indicated that he would consider granting a motion for a mistrial if we moved to a mistrial, saying that it was on us and not on any conduct on the state nor the court.
So the judge told you or hinted that if you were to request for a mistrial, you would have to first absolve the state or the court of any fault.
That's correct, yes.
And then you would only grant a mistrial if you or the defense were to admit that they were at fault and that mistake or errors was the cause of the mistrial.
That is correct. That's when it first happened.
And you would not grant a mistrial if we were not going to acknowledge that we made mistake during the trial.
Yes, that it was the court's or the state's mistake, somehow he would not grant it.
Okay. And was that repeated also in open court, or was it discussed at some other point?
Yes. So the day that the mistrial was granted on June the 4th, we went up. He went up to the bench, and he brought up that same suggestion, right? Like he would consider granting the mistrial if we were to blame it on ourselves and not the state or the court.
Okay. Did you, during the trial, did defense counsel try to qualify their experts?
During our case in chief?
Yes.
Yes, we through the 702 and 705 hearing that we conducted.
Okay. Did we try to challenge each of the state experts under 702 and Dover be to have double hearing for each of their experts?
We did.
Okay. Despite they refused to have his 702 hearing before or during the state's experts' testimony, did the defense attempt to conduct 705 hearing to inquire on the basis for which the expert expressed an opinion?
We did, even through cross-examinations, we tried to get that out.
Were we allowed to conduct the 705?
We
examination?
were not on some of, especially on Dr. Ross, we were not allowed to go into some stuff that we wanted to get into.
The idea and the origin of granting a mistrial if the defense admits mistake, where did that originate from?
The idea of blaming of us as defense counsel blaming ourselves for a mistrial kind of all started when the judge brought that out in chambers first.
Okay. Then pass a witness, Judge.
Mr. McCarthy?
Thank you, Judge. Good morning, Mr. Avila.
Good morning, Mr.
Nice
McCarthy.
to meet you. I look forward to meeting you in person.
I agree.
And if it sometimes seems like I'm looking off, it's that I keep getting tempted to look at the better screen, which is the bigger screen that I have. I've noticed that I'm doing that, so I'm sorry about that. I'll try to not. Thanks. I got a few questions for you. Excuse me. In direct examination just now, you said you sort of recited the important periods, really all the periods of the trial that you were present. And one of the questions was whether you were present during the defense case in chief. And given the lack of record, I ask you, was there a defense case in chief?
In it in front of a jury, there wasn't.
So you put on, I guess you put on your two experts outside the presence of the jury, correct?
That's correct.
And that ended up being the sum total of the defense case in chief. Is that correct?
We had other potential witnesses after the fact, including lay witnesses that we were considering, but before the mistrial, that was the extent of our case in chief.
I believe you testified that there was a hearing, a special hearing on the admissibility of the testimony of the nurse practitioner. Is that correct?
Yes, we had a hearing on on her qualifications.
Okay. You mentioned, as I heard you, an agreement with the state that the nurse practitioner could testify subject to its 702 hearing. Is that what you said?
That's correct, yes.
Thank you. Now, well, sorry, let me ask you something else first. Well, sorry. The agreement with the state cannot bind the trial judge in terms of the court's discretion, correct?
Regarding presentation of witnesses, you know what? I'm not too sure, Mr. McCarthy.
And you mentioned a request or motion for hearing on the nurse practitioner, and that request would have been for a 702 hearing. That's what you said. Is that right?
702 and a 705, yes.
Okay. And to go back to what we were talking about a few minutes ago, you testified that there was a hearing on the nurse practitioner.
There was, on her qualifications, there was.
Were you able to, was the defense able to cross-examine the nurse practitioner?
We were allowed to cross-examine the nurse practitioner, maybe not some of the points that we wanted to get into because of some interruptions from the court, but we were allowed to cross-examine her.
Okay. Were you allowed to ask her questions about the underlying facts or data on which she was basing her opinion?
I don't recall.
Um, okay, so you regarding these conversations in chambers, when it starts to come up about a possible mistrial, which you testify, if I heard you correctly, you're saying that as far as, I'm sorry, for the record, and just so we're clear, including myself, we're talking about a period after Mr. Shelley has left, in the sense that he took his trip and he's not part of the defense team in terms of being there at present, right? These talks in chambers that you were talking about.
Mr. Shelley, when we began our case in chief, was no longer, he had already left out of town, so it was Ms. Pages and I that were, I guess, conducting our case in chief.
And it was then that when you're talking about these talks in chambers that lead to this idea of a mistrial, you're talking about that point, sort of the beginning of the defense case in chief, and in chambers is the judge, yourself, uh, uh, Ms. Pages, uh, and the assistant district attorney, Jonathan Amder. And is that correct?
That's correct, yes.
Okay. And so you were saying in your testimony, I need to be clear on this, that Judge Lizarra was the first to mention the possibility of a mistrial.
No, if I can clarify.
Yes, sir.
Judge Lizarraga was the first that popped the idea of a mistrial blaming us. Before that, we had been asking for a mistrial given multiple things, right? Especially, I think we asked for a mistrial right before we asked for a directed verdict. We asked for a mistrial after the 702, 705 hearings were disallowed. So the idea, when we went in chambers, the idea of blaming us for a mistrial was the first time that it kind of popped up.
Okay, I don't want to belabor us, but you happen to remember, like, when the defense first asked for a mistrial.
Mhm. Oh, you're asking me when the first time it was that we asked for a mistrial?
Yes, sir.
I don't remember if it was Mr. Shelley after he was denied the 702 hearing and 705 hearings, or if it was Mr. Shelley after There was some discussions that occurred in front of a jury. I honestly do not recall, but I do believe those were the first few times that we started asking for mistrials.
And in terms of, well, there's a chart, not a chart, there's a chronology laid out in Mr. Shelley's petition, or rather Mr. Rodriguez's petition, laid out, and that gives some timelines. So help me. I think it was the very end of May that the trial itself started. Um, is that right? I actually let me. I think I can help. I would just like to see if we could find out. You know, I mean, you. Well, excuse me. Um, and it may not recall itself to you if you don't remember it actually, and you don't have the document to look at. So I guess it's really not fair to start talking about exact dates if you don't have it with you, and I don't want to sort of make a deal about that. I want to get you have stated that we might say several times a mistrial was requested. That's correct.
On the defense side, we did ask for multiple motions for mistrial.
Okay. So we're all, this is sort of the last question about trying to find out like when that started, because we're not going to know for sure anyway. But did that start happening like in the last third or so of the state's case in chief, or did it start earlier than that, middle of trial, early in the trial?
Would say I'm not 100% sure, but I would say the motions for mistrial began around the midpoint of the state's case in chief. Our motions for mistrial.
Um, and finally, actually, uh, Mr. Avila, have you? I'm sorry for my dry thing. It's something new. Sorry, but have you reviewed the excerpt uh, that we have of about 60 pages, which is State's Exhibit number 4? Have you reviewed that excerpt?
Are you talking about the excerpt from your response?
Yes, sir.
I remember reading it or referring to it. I do remember skimming it as well.
Okay. Would you agree that the defense had the opportunity and in fact did ask 705 questions of Dr. Ross in that excerpt?
I would disagree with that, that we were given the opportunity to ask for Dr. Ross's basis for his conclusions.
Yes. Would you agree that you were able to ask various, I'm calling them 705 questions, but yes, about the underlying basis or data that he was using to form his opinion, that the defense, were able to, in that excerpt, that excerpt shows that you were able to talk to him and ask questions about the underlying basis and data of his opinion.
I honestly do not recall. What I can say is I don't think we were fully allowed to do the 705.
And one last, actually, to be clear, because we have the excerpt and then we don't. So, did you? I mean, we know some things about what happened the next morning in terms of Mr. Shelley being excused, but did you continue, or did Ms. Pages continue uh, the cross-examination of Dr. Ross?
I believe it was Ms. Pages who concluded or finished the cross-examination of Dr. Ross.
Thank you, Mr. Harvey.
Just
That's the witness.
okay.
Correct.
I just have two follow-up questions, Jeb.
Sure.
Mr. Avila, do you remember before Mr. Shelley, and I'm going to talk about myself in the third person to make it easy for the record. Mr. Shelley, before he left, the judge asked him and other counsel to come early the morning he was about to leave to court.
You remember that? Yes. He
remember-
asked us to get there at 8 in the morning, if I remember correctly.
Do you remember why he asked him to come early that morning?
If I remember correctly, the reason we were asked to come in early is so Mr. Shelley, and again, I'm referring to as a third person, so Mr. Shelley can finish the cross-examination before he left.
Do you also remember that the judge asked Mr. Shelley to come early so he could excuse him in front of the jury?
Oh, that's right. Yeah, so it didn't seem like Mr. Shelley was being kicked out of the case or anything like that, so the jury could understand what happened on that end.
Okay. So, and in that morning, Mr. Shelley, Miss Page, and yourself, as well as the prosecutor, were present at the time the judge asked them to come.
We were. I remember that.
And the plan was for the judge to excuse Mr. Shelley in front of the jury,
That's correct.
so that the jury would not infer that there was any misbehavior and that Mr. Shelley would be dismissed by the court.
Yes, it was a question of the appearance to the jury, just making it seem like it was that he was excused because he had a trip.
Did that happen? Did the judge dismiss or excuse Mr. Shelley in front of the jury?
It did not. Mr. Shelley had to leave. We went in chambers. We began talking with the court. And then in the middle of talking with the court, Mr. Shelley had to excuse himself because he had a flight to take.
So let me try to refresh your memory here. When you, Mr. Shelley, and Miss Page and the prosecutor went into a chamber, was that a discussion or was it more a presentation by the court? Do you recall what happened there?
I do remember it was the judge talking to us. I don't remember exactly what he was talking about. Honestly, I don't remember, Mr. Shelley. I don't remember the contents of the conversation.
At the time, the judge took all the parties in chamber and engaged in the discussion. All the parties were present.
That's correct, yes.
And the jury was also present and waiting at that time.
The jury did arrive that morning, early that morning. They arrived after we arrived to the court, but they were there in the jury room.
So, and despite the judge request that the party come so Mr. Shelley could be excused to remove any possibility of impropriety for his absence, that did not happen, right?
In front of the jury, it did not happen.
Okay, and Mr. Shelley had to leave and never had, the judge never really had a chance to excuse Mr. Shelley in front of the jury to explain that. Was there actually questioned by jurors regarding, or do you know whether or not there were jurors wondering if Mr. Shelley had been sanctioned by the judge?
I do not know. We didn't talk to the jury.
Okay, all right, pass the witness, Judge.
McCarthy?
Thank you, Your Honor. Mr. Avila, do you agree that, well, I actually think you said, but I just want to make sure, it was the judge's plan, and it was discussed that Mr. Shelley was to be excused in front of the jury, and it was the judge's intent to do that so that there'd be no implication or imputation or anything about Mr. Shelley or in his conduct in the trial. That indeed was the judge's plan.
It was not to show any signs of impropriety in front of the jury or anything like that.
Right. Okay. That's the witness.
No further question, Judge.
All right. Thank you. Mr. Avila,
Yes, Your Honor. Sorry about my cough, Your Honor.
yeah, no, that's fine. I do have a question. I'm going to ask you, Mr. Avila, just because we don't have the benefit of a record here.
Mhm.
So, when the mistrial was granted, and I understand it to be an oral motion to the court, is that correct?
It was, Your Honor, yes.
Okay. Did y'all state the basis for the motion for mistrial, or did you just ask for a generic mistrial?
No, Judge. Thankfully, the judge did allow us to state the basis of our mistrial, and Mr. Shelley, as well as I, and Ms. Pages as well on one of her motions. The judge allowed us to state all of the basis for our motion for mistrial.
And what were those bases?
Judge, one of them I know for a fact was we asked for a mistrial because of the court disallowing us a 702, 705 hearing on the state's experts, as well as the court asking for or doing a 702, 705 hearing on our experts without the state petitioning. One of them was and I must apologize, Judge. I've had at least 2 or 3 trials with Mr. Isaraga.
No. That's fine. When the order was signed, I'm assuming it just said granted, right? If there was a written order, or was there no written order? It was granted from the bench?
It was granted verbally, Your Honor. There wasn't
Okay.
a written order or anything like that.
Okay. And so, to the best of your recollection, it was a 702, 705 hearing that y'all requested of the state's experts that was denied, and then the 702, 705 hearings that were conducted on the defense witnesses without the state's motion or petition or an Kelly Daubert hearings on the state's experts. And do you recall any other basis?
Yes, Judge. One of them was we were not allowed to fully cross-examine the state's experts through routine interruptions by the court. We were not allowed to get into some things that we wanted on cross-examination to present a full defense. I remember we brought that up. The second one, there was one, and I think I would rather this record speak for itself on this one, and that was something regarding a motion for a mistrial due to the court's behavior in front of the jury, how the court was responding to us in front of the jury. We did make a motion for a mistrial on that end. And then, if I remember correctly, we also made a motion for a mistrial. We did move for mistrial during our right before we did a directed verdict. And again, it was just our inability to effectively cross-examine even the lay witnesses. If I remember correctly, we did indicate something like that, as well as the expert witnesses.
Okay. Thank you.
I just have one follow. If the court has no more question, I just was gonna the instance of mistrial you described, Mr. Avila. These were the instance in which the defense requested a mistrial, and these mistrial were denied.
That's correct. The only one that was granted was on January the 4th, which was our last day of trial.
Okay, and
Or excuse me, June the 4th. Sorry, I
June the
apologize.
4th.
June
And
the
those,
4th.
but those, go ahead, I'm sorry.
I wasn't sure the ground for which the court granted the mistrial. What was the ground on which the court granted the mistrial, Mr. Avila?
So, um, I'm trying to make memory here, and when I remember when I made a motion for a mistrial, I indicated that it was in agreement with the court's findings, and if I remember correctly, the court did make findings afterwards. He indicated that it was due to the defense counsel's conduct and nothing to do with the court or the state's conduct. I am drawing blanks on the details of the exact wording.
And I may, if I may direct the court, there is an order granting mistrial that was entered, I believe, several weeks after. In that order, along with the remedial order written by Judge Lizarraga, there is a description as to why he grants the mistrial. There is also indication in that order, Judge, and if I don't know if you have it, but I can certainly email it to you and Mr. McCarthy, explaining that Judge Lizarraga explained that he's granting the mistrial through no fault of the state or the court. And that is what he's writing in his order. And I have passed the witness. I have no more questions, Judge.
All right, thank you very much. Mr. McCarthy?
I think if you remember, Mr. Avila, or if you had a chance to look at what is State's Exhibit number 3 in this petition, which is a remedial order by the court of 25 June 2024. Are you familiar with the contents of that written order?
And sorry, Mr. Avila, let me just ask one question. Mr. McCarthy, I've looked at what you sent me. I haven't looked on Odyssey what was filed. I'm understanding from your questioning that there was an attachment to your response to the writ. Is that correct?
Yes, Judge.
I did
I think it's Exhibit number 3, and it's styled. I mean, it's
okay.
Remedial order.
Let me just stop you there. All I have is your response. I don't have any. If you attached any accompanying exhibits, I do not have those.
Neither.
So I was looking for them, and you were referring to a 60-page exhibit, I think State Exhibit number 4. I'm assuming you're referring to the remedial order.
May I mention something really quick? So, Mr. McCarthy, when you send us his response, there were no attachments, but in his motion, he did submit the exhibits. And his motion, he actually filed. It's a 206-page motion as well.
Okay, so I've only got the motion. I don't have any of the exhibits.
Okay. So that was obviously, and I guess that it was a mistake to send it the way I did. I mean, I can go back and, I think I know what I wrote to you in the email and all, but I know how email communications are. And so I guess I should have been more exacting. And I probably should have either not sent you a courtesy copy at all, or I should have sent you the whole 206 pages, because the 206 pages, which includes the 4 exhibits, is in fact on portal, as Mr. Avila just mentioned.
Okay. Let me just so the thing about it is that yes, I have the ability to go into Odyssey and read what's filed. If these are exhibits that you want, and based on what I'm understanding, these are exhibits, and I'll ask you that in a minute, that are in the court's file, so you can ask me to take judicial notice of those things. And for the purpose of this hearing and for a proper record, that's probably what you want me to do, right?
Indeed, thank you for, yeah,
Okay, I just,
putting
but I
that,
just
putting
want to
it
be
that way
clear.
as a solution, because of course you can take judicial notice. It is in the record. And we can, we could talk. So
Just
what has been referenced for the record,
right.
what have been referenced as states exhibits numbers 1, 2, 3, and 4 for purposes of this hearing, the state would ask the CART to take judicial notice of the court record wherein such exhibits are found as part of the court record in this case.
Okay. And Mr. Shelley, do you have any objection to that?
I don't have any objection. The court take judicial notice of the entire file. As a matter of fact, I think that would make it just far easier.
Yes, no, that of course, the court does take judicial notice of all of the filed pleadings and motions, et cetera, contained in the file that is contained in the clerk's record. So I just want to be sure that I just want to be sure that I fully understand that. I'm actually familiar with some of those filings, not all of those filings. But proceed, Mr. McCarthy. I think I interrupted you, and I apologize.
Not at all. You solved a glitch. Thank you. So Mr. Avila, regarding what is styled remedial order from June 25, 2024, are you aware of the, do you have knowledge of what that remedial order says?
Not off the top of my head, but I do remember having read it at the onset during our writing of the motion and all that.
Okay, and you may or may not remember. I understand, because
If I can,
having,
with the court's permission, can I refer to it if I can?
oh,
Sure.
Okay.
Of course.
Okay, I know it's kind of weird because I'm technically a witness. I'm not supposed to be referring to anything outside, but I have the remedial order.
okay. Oh, and have you reviewed it already?
Not recently,
take your
but I
time.
remember I reviewed it.
I didn't understand. Take your time.
And when we're talking about a remedial order, could you give us the date, Mr. McCarthy? Because there are several order and remedial orders. Which
June, yes. It's a 25th day of June, 2024.
Is that the remedial order or is that the special finding?
This is not the special findings. It is styled, headed remedial order.
Of June 25th, 2024.
Yes, and
Okay.
yes, ma'am.
Yes, I've had an opportunity to read it. Yes.
Thank you. Okay. Now, that remedial order that we're talking about of June 25, 2024 makes no mention of it does not make any mention of ineffective assistance of counsel. Do you agree with that?
It's remedial order. You're correct.
Was that an agreement? I'm sorry.
Yes, this remedial order makes no mention of any claims of ineffective assistance of counsel. That's correct.
Thanks. Thank you. pass the witness.
All right, Mr. McCarthy, let me just be sure I understand. State's Exhibit 1, so that I know that to focus on the exhibits that you are specifically relying on your response to the writ, is State's Exhibit 1 is the special findings that Judge Bisaraga filed. And I understand State's Exhibit 3 is a remedial order of June 25th of 2024. I'm unclear what State's Exhibit 2 and State's Exhibit number 4 are.
Okay. Yeah.
I think
If I can start with,
is
sorry,
the order is State's Exhibit 4 the order appointing Mr. Solis?
that's State's Exhibit number 3.
Oh, okay.
Appointing Mr. Solis is part of the remedial order.
Okay.
Yeah.
Okay.
So State's Exhibit 4, if I can start with that, is straightforward and important. It's the excerpt. It's called excerpt. In fact, it's 60 or 70 pages of transcript. It contains the cross-examination, or the first part of the cross-examination, of Dr. Ross, and exchanges between the CART and counsel for the defense. And it's the one excerpt we have from the trial that I'm aware of.
Okay, and that is filed in the court's record?
And that is also filed in the court's record. Yes, ma'am.
Do you know?
I'm very confident of that. Of course, I can.
Do you have a filing date? Or was it attached? Was it attached to the special findings?
It was attached to the special finding.
Okay.
And it was filed on June 27, 24, Judge.
Okay, and the special findings were also, I'm assuming, filed June 27th, 2024?
Yes, Judge. There were
Okay.
two special findings. One was filed on, both were filed on the 27th, Judge.
Okay, that's fine. And so State's Exhibit number 2, what?
Okay, it's called. I don't even have I have my response here, but I don't. Okay, yeah.
Let me look at.
I am afraid that I included State's number 2 because I thought it was slightly different than State's number 1, the special findings, but I think it is effectively the same thing, in fact. But there are, in fact, 2 different filings. That is to say, there were 2 different documents in the court file.
And were they filed on the same date or around the same date? So you're saying that there's a second special findings that was
Yes.
filed?
Judge, and I may clarify this. What happened is 2 special findings were filed at the same time on the same date. One is 1-page document, which is only the first page of the other one. So one is 60 pages and one is 1 page. And the one single page is the first page of the 60-page document filed by Judge Lizarraga.
Okay.
And I'm sorry, but I did not file the 1-page document.
No. That's
Okay. I didn't file that. I filed 2 large documents.
okay.
And what I'm afraid, Judge, is that they're probably I think they're almost exactly the same document, but not entirely the same document.
Okay.
I'm sorry, they're both in the court file.
Okay. I just your response didn't make it immediately clear from context what you were referring to, but and I want to be able to specifically see that because it wasn't included, and so I want to be able to specifically look at it. All right, gentlemen. Any further questions of this witness?
No, Judge. There's no question.
All right. Argument, it's your motion, Mr. Shelley.
Thank you, Judge. I think as our motion indicated, the question is typically whether or not the defense is goaded into asking for mistrial and terminating the proceeding. Here we have Mr. Avila who testified that the defense, who had the trial, requested mistrial. Throughout the trial, the defense was denied that mistrial request. And sua sponte, the judge decided that he would consider a mistrial under certain conditions. And they were necessary and exacting conditions. He would not allow mistrial if the defense were going to repeat, for example, the ground that they had studied previously, any of the ground. Mr. Avila specifically said that the judge would grant the mistrial only if the defense admits, in short, some kind of wrongdoing. That is confirmed by his order of June 27, where if you look at why that order, we're not talking about the remedial order, we are talking about the special finding with the order for mistrial. That order for mistrial specifically indicate that counsel was ineffective. Counsel was, I would say, misbehaving. So the court's own finding indicate that the court granted that mistrial on these grounds. These grounds are explained at length. So we have the court here goading Mr. Avila into asking for a mistrial, telling Mr. Avila, I only going to grant it if you admit to these grounds. And then you have the special finding where you have confirmation of Mr. Avila's testimony regarding the goading. This is, the court doesn't have to think or wonder what is in the mind of Judge Lizarraga. And the court is aware that typically that is a question. What is the prosecutor thinking? What is the court thinking into the goading? Here we have it. We have unrebutted testimony from Mr. Avila, which is confirmed by the special finding by the court as to what is the reason. And in the first paragraph, you have that quote from the court in the special findings. So if you tell me what you want the mistrial based on my observation, and with that reasoning, I'll grant it. That is an excerpt from the record. So to determine if the request for mistrial were requested because the judge or the court goaded the defense into it, the answer is clearly yes. We have unrebutted testimony, and then we have the word from Judge Lizarraga himself declaring the same. So we have met our burden on this. We have a burden by a preponderance of the evidence, I believe, and we have met that burden. We have established that the defense was goaded into asking for mistrial because of whatever action Judge Lizarraga engaged on or accused the defense on. At that point, the defense had no intention of requesting a mistrial on the ground articulated by the Judge Lizarraga. That originated with him. Because we have established clearly from the witness, unrebutted, and from the word of Judge Lizarraga that he goaded the defense into a mistrial, which he granted, therefore. We ask that Mr. Rodriguez not be subjected to another trial. We establish all the elements for double jeopardy, and I believe he should be protected from double jeopardy, Judge.
Thank you. Mr. McCarthy?
Thank you, Judge. And thank you for making clear that you've read the cases. They're cited. And so I will try not to be very repetitive on that. And I guess another housekeeping is with respect to counsel's representation, which by no means I doubt about the written order that does mention ineffective assistance of counsel that he says he's going to send to us. It's just, yeah, I think that would be important to have for all of us to have. Okay. And so thank you for that. Okay. So, as Mr. Shelley said, I mean, one of the most important thing really from the cases is that what I would refer to as the effective standard of review is the intention of the trial judge. Assuming arguendo only that there even was misconduct, which we would also deny. And confident the record would show, the whole record would show, and indeed, the little bit we have shows that there's no misconduct in the first place. But if you were to answer, so to speak, the first question, that there were misconduct, then the standard of review would be intention. And I think it's important, although I know you read the cases, that Mr. Shelley acknowledges in his own petition, and I made clear, I hope, in my response, that the standard is intentionality, and that is the Supreme Court standard, that is to say, United States, and that is also the Texas standard under common law and under the Texas Constitution. And that's actually stated. There's a little bit of confusion in my opinion, in Mr. Shelley's petition about that, but I think that that's clear. The Kennedy standard, as I refer to it, intention. Okay, so what I would like to suggest is the following. We have in the petition itself testimony, Mr. Shelley's, in addition to Mr. Avila's. Mr. Shelley has affirmed an affidavit saying that the allegations that he's making about facts and what happened are true and correct. Okay. And so the state accepts that can be considered as evidence. We would not cross-examine Mr. Shelley on his testimony. But more importantly, we have testimony from the trial judge himself. He tells us what his intentions were. He tells us what his state of mind was at the time. We have the special findings. The court, which is to say, Your Honor, has taken, I believe, in her judicial recognition of the exhibits that I had filed from the court record, has also taken judicial notice of the entire record. And indeed, one of my exhibits is the special findings. So I believe that's in evidence, and that's effectively testimony. And so the court will, of course, read that for itself and make its determinations. And it's not for me to go through it vastly, but if I may just point out a few things that give us an idea of what the real intention was of the trial judge. In the special findings, he cites instances of ineffective assistance of counsel, and he cites quite a few. And I'm not going to, mention them all. And I also don't want to imply that there were so many either. I didn't mean that. But he cites more than I'm going to say. He talks about right away. He thought it was ineffective assistance of counsel on the part of the defense counsel to not challenge what he found to be a very faulty problematic, vague indictment by the state. That is in his findings, okay? So he also talks, and this, I don't know if you're going to use our state's exhibit, we bait stamped it as 005, but he talks about the judge's actual perspective at trial. He actually uses that term, actual perspective at trial, was that defense counsel was ineffective. He talks about saying that he's helping the defense. And he specifically talks about that he is protecting the constitutional rights of the defendant in making his decision for mistrial. So he says other things I have written down here, but I don't really think I need to try the court's patience on that. I do have a number of other things written down. I think my point is clear that the special findings, although they may be long, do in fact reveal what the judge's intention was, what the judge's thinking was, what the judge's motivation was. And, Your Honor, as between Mr. Shelley's view and the judge's, the person that would know best what his intention was in the first person, the person who would know best what his intention was about something would be that individual who's being examined. Now, I may have put that wrong, but what I'm trying to say is, you know, it would be rare that how would I put this? That the witness who is not inside the mind of the person whose intention we are examining would have the better perspective on what the intention was, rather than the actual testimony of the subjective individual himself of what his thinking was at the time. I think that's, and I would also, I'm sorry, Your Honor, want to emphasize, and I think you'll see when you read the brief excerpt that we do have, that in fact, Mr. Shelley was able to get into 705 material with Dr. Ross, and that's the only excerpt we have of any kind of exchange with an expert, and he was not prevented in any way from getting into underlying bases and data. And there are instances of where he talks specifically about things like the images, whether he had done measurements. He talks about a number of things having to do with bases and data for the opinion of Dr. Ross, which gives us, you know, an indication that the defense was not prevented from those lines of questioning, of which it's complaining. Therefore, thank you for your patience. Obviously, the defense urges this court to deny the relief sought in the petition for writ of habeas corpus / double jeopardy.
If I may respond quickly, Judge.
Please.
I'll start with just correction of the record, I would say, regarding the testimony of Dr. Ross. Then I will go into the meat of the legal argument here. I was not allowed to take Dr. Ross on 705. 705 is the base of the knowledge. This was a shortfall case. I was not allowed to ask any question about shortfall. The court can look at the records. There's actually, I make objection specifically about trying to get into shortfall and literature of the shortfall. That was denied. No question were allowed. And I tried again to question Dr. Ross about shortfall and the basis of his opinion that shortfall could not have been the cause of the injury. I was prevented. So to argue that the defense was allowed to examine Dr. Rose on the basis of his testimony is just plainly false. We were not allowed to examine it on the critical issue of the case, which was shortfall. Now, regarding the legal argument we are making, the legal argument is did the court goad the defense into asking for a mistrial? And none of Mr. McCarthy's argument addressed that point. In George v. State that he cited, and if you look at 244 of that opinion, it's a case where the challenge for cause was denied, and the question was, well, did the judge deny the challenge for cause with the intent to cause a mistrial? And the court says, you know, in this case, there was no evidence to suggest that the trial court denied the challenge for cause with the intent to cause mistrial, or that he knew that it was likely that the defense would move for mistrial, and that he would probably grant it. That was in George v. State. Here in this case, we have the exact opposite. We have unrebutted testimony that the judge articulated the reason for mistrial, that he would only grant it if the defense would agree to these terms, that option choice that we described in our motion. And then once the defense move on the ground that have been articulated by the judge grant it. And then you have the judge entering his finding to then explain or rationalize the reason for the mistrial. We have here, we don't have to presume or to ask what was Judge Lizarraga was thinking, because he wrote it. If the state wanted to know what Judge Lizarraga was thinking, or believe that the Judge Lizarraga was not thinking like Mr. Avila, the state could have called Judge Lizarraga as a witness. They choose not to. We have a burden, we met that burden of preponderance of the evidence. The state could have called any witness, introduced any evidence. Judge Lizarraga could have been called as a witness. The state chooses not to do so. It is through no fault of our own that the state doesn't meet their burden or doesn't rebut any of the evidence presented. They have subpoena power just like we do. So this is not an act of divination. We are just looking at the fact, what has been written and stated, and that is sufficient for us to carry our burden. And if the state wanted to dispute any of these, they could have brought any witness, or even Mr. Andrew, or prosecutor, or any other person who had been there to contradict anything Mr. Avila has testified to. And for this reason, we ask the court to grant our petition and to give relief to Mr. Rodriguez, because we have met our burden of preponderance of the evidence.
All right, gentlemen, I'm not going to.
You don't want to hear me, okay.
No, honestly, I've looked at the cases, and I really want an opportunity. I have reviewed in preparation for this case when I was assigned it. I did do a cursory review of the court's file. I have read the special findings, but that was some weeks ago. So I really need to sit back and look at that. I probably only have a couple of questions, and I hate to give y'all homework because nobody needs homework. But I do want to be fair to both of you, and the way I understand it. So if you want to file something very brief, I'd say 1 to 2 pages, is the way I understand this area of the law is, it's a little bit akin to, it's prosecutorial misconduct, what I call misconduct by the trial judge or the trial court. And I think the first U.S. Supreme Court case that identified that a defendant is subject to double jeopardy, or is placed in double jeopardy, is when the trial court commits, I don't want to say an act, but an act, can be a commission or omission, that is clearly misconduct. Just like y'all are familiar with prosecutorial misconduct, we're all familiar with some of the examples of that, and it's clearly those behaviors or conduct. I don't want to say that they're illegal. They're certainly unethical. I think, and if I recall that first U.S. Supreme Court case, and I'm paraphrasing here, so was something like the jury had returned a not guilty verdict, but the judge granted a mistrial so that the defendant could be tried again in spite of the fact that the jury had given a not guilty verdict. So, my question here is I understand. I think the evidence seems to me to indicate, I don't know about goaded, but certainly encouraged, and talked about a mistrial on these specific grounds. So then the question becomes for me a couple of questions. Firstly, is the denial of the 702 and 705 hearings, and it's not just error, because if y'all read the cases that I have, it's not just the trial court committed error and was mistaken about the law, etc., those kinds of things, and that could be remedied by appeal, right? But is the law completely clear that even after the defense makes a motion and then it's denied the right to conduct a 702, 705 hearing, does that rise to the level of misconduct? That's my first question. I looked at the cases. I found that I didn't find any case that says that. Maybe y'all will find one. I found a case that said even if the court doesn't conduct those hearings and still allows the expert to testify, and this was in a DWI case, if it was to science that's very well established and that has been admitted across the courts, and then it's not error. So that's part of my question is, so, and y'all raised two bases for that, is the denial. Y'all made the motions. The trial judge denied your 702, 705 hearings as to their witnesses. And then the second part of that is the fact that the trial court, sua sponte, conducted 702, 705 hearings on your experts. Error, but is it error that is so egregious that we would call it misconduct? I cannot find a case that says that. In fact, my reading of the cases says the trial court, we've all heard the language, is the gatekeeper, and the trial court has a duty. And based on the language I looked at, regardless of whether anybody asked for it, they have that gatekeeping duty to, if an expert is going to, and this I think comes from some of the U.S. Supreme Court cases, if an expert is going to testify, the trial court has the duty to conduct that hearing to ensure that that expert is not going to confuse the jury, right? And to be sure that the science is reliable, absent objection or request from either side. So So my next question is, the fact that the trial court conducted these hearings, absent request, absent objection, is that not only, not only is it just plain error, but does that rise to the level of misconduct? And then the third question I have is, hypothetically, if I'm a trial judge, let's say, and I hope I will never do a death penalty case, but anyway, if I were doing a death penalty case and the defense attorney clearly is ineffective, the defense attorney is laying his or her head down and snoring, what is my duty? If hypothetically, and I'm not saying that that's what y'all did, please don't misunderstand me, okay? I'm just, I've been 12 years up on the 13th floor, as you would 12th floor up there, and so that's the way I think about things. Is if a judge suggests to counsel in a criminal proceeding that maybe they need to file a mistrial because he or she, in good faith, believes the defendant is getting, the counsel is ineffective, to the point where the defendant's right to a fair trial has been, I don't want to say abridged, but the defendant's not able to get a fair trial. Is that, and that's what y'all have both kind of argued to me, and that's the way I understand the argument. So correct me if I'm wrong. That the trial judge goaded the defense into asking for a mistrial, and both of y'all are saying the intent, and you're right. The judge's intent is critical here, and by virtue of what Judge Lizarraga filed, he made as clear as he could what that intent is. And that intent was his belief that in this trial, under these circumstances, that it was that counsel was ineffective. And so is that misconduct? Is that misconduct that rises to such an egregious level that justifies double jeopardy attaching? And I think y'all have kind of all said that, but that's what I see. I would like an opportunity, like I said, to read everything all over again, and to look at the cases. And if y'all have any cases, I didn't see any. I mean, I think you guys, Mr. Shelley, I think your writ had maybe, there are very few cases in which double jeopardy attaches as a result of the trial court or trial judge misconduct. We got a lot, we probably have double, triple the amount based on prosecutorial misconduct, but very few based on the judge's misconduct. And we kind of have to look at it in a vacuum. We don't have the benefit of the transcript, which I don't know that it would be very helpful, to be honest with you, because I think y'all all agree as to, for the most part, as to what Judge Lizarraga's intent was. So I think that's going to be the difficulty. I've looked, if y'all find some that can give me some guidance, I would appreciate it. I wouldn't spend a lot of time on it unless you choose to do that. I would like to be able to make a decision next week. But there are very few cases, and I think we can only look to the cases that we have in front of us for guidance.
And I believe in the first impression before this court and before.
I'm sorry, can you start over again?
Yes, I believe it is really a case of first impression on the ground. There is in Texas and actually across jurisdiction. I look at other jurisdiction, Judge. Our
the-
fitness is out there, but in Texas, it would be really at the appellate level, first impression, I believe.
Yeah, and I think the cases over and over look to, obviously when I think about that first U.S. Supreme Court case in which a judge, knowing that the defendant got a not guilty verdict and granted a mistrial solely to defeat that not guilty verdict so that the defendant would be subject to trial again, even after a jury of his peers or her peers found them not guilty. I mean, that to me is super egregious, so I hesitate to say that the misconduct has to be illegal is not the word I'm looking for, but it's got to be so egregious that it's that the rulings that are the intent of the judge in those rulings that force where you felt like you were forced into moving for a mistrial have to be I mean, that's just the misconduct has to rise to that level, I think, to a degree. And unless we have some case law that says as to the 702 and 705 hearings, that the rulings in and of themselves are so egregious and so that they, and for a judge to ask for or suggest a mistrial based on his or her perception that the counsel was ineffective, how that's depriving your client or any defendant of a fair trial. I think that's the linkage that we would need. But at any rate, I appreciate y'all's presentation. Everybody did a fantastic job. I really appreciate it. This is you're right. It would be a case of first impression, not only I think here in the 8th district, but across the state. So but I think if y'all can find any cases that will speak specifically to the 702 or 705 hearings and either the denial of those hearings or the sua sponte granting, and then I don't think there's anything out there, but if a mistrial, if a court suggests a mistrial because they had a belief of ineffective assistance, does that rise to a level of misconduct by the judge?
Where there is a case, and I believe it's Saddle White v. State. I'm not sure about the name. It may be wrong, but there is, I remember from law school in Texas, defense counsel can fall asleep at counsel table and still be found effective as long as he's not sleeping during critical stage of the proceeding.
I think you're right. I think they.
That's not.
I think they walked that back after a while. I don't think that's. So, I don't think that's. I hope that's not the current law. I don't know. I'd be banging my stuff around on my bench if somebody fell asleep. I'm used to judges falling asleep, not used to counsel falling asleep. You were going to say something, Mr. McCarthy?
Well, I did, and gosh, you might see counsel fall asleep someday. I'm getting so old, but that made me laugh. I'm sorry about the judges. I also thought that although I don't disagree that there may be a case that says something like what Mr. Shelley says, but I thought that your hypothetical had to do with the perspective of what the judge should do You actually, I think, said what is my duty, and the hypothetical is if I were on a death penalty case as a judge, and defense lawyer was clearly ineffective, and I put in sleeping on the floor, but I think you said lying down asleep or something, or I don't know, but
Their head on
like,
the up, yes.
yeah, something, head on the table. Right, I should head on the table. Okay, what is my duty? I mean, that was the first hypothetical. So that doesn't necessarily have to do with whether some court might say, well, Your Honor knows much better than me about judicial duty, but I think I understand. It's what is the judge in the judge's conscientious, carrying out of his duty. What's his real duty? Okay, and so I kind of think that case is. I feel like it's irrelevant, and I'm not really planning to address it as to whether or not somebody ever said that somebody could have fallen asleep.
No.
Your
no,
hypothetical is
that
beyond,
was,
it's kind of beyond that.
yeah, no, Mr. McCarthy, don't misunderstand me. I'm not asking you to answer that hypothetical. This is what I just pose that question so that you'll understand. I think the third question, absent the denial of the 702, 705 hearings, the sua sponte conducting 702, 705 hearings on the defense expert, and then thirdly, is it misconduct by the judge to suggest or recommend or ask for counsel to make a mistrial based on that counsel's ineffective assistance? That's really the question, right? Because I think you both agree that was Judge Laraga's perception. That's what he states in his over and over again in his special findings, based on my recollection of reading them. And that's why he wanted to make it very clear when he granted the mistrial on the order that it was not based on either the trial court or on the state, but was based, he granted it based on his perception of the ineffectiveness of defense counsel to the degree that it was affecting the defendant's right, Mr. Rodriguez's right to a fair trial. That's what I understand.
I do understand, Your Honor. Thank you.
So those are, I mean, if you can find any cases, I don't really need argument. I don't need explanation. But if you can find any cases that will help illuminate those questions, that would be helpful. And if you can't, don't worry about it. So anyway, let me not belabor all of this. So let me let y'all go, and we'll be back at just some housekeeping matters. I know, Mr. Shelley, that we had one of your experts at 1:30. Is that correct?
Yes, Ms. Page will be presenting Mr. Galaznik, Dr. Galaznik.
Dr. Galaznik, right. And then I don't remember, and I wasn't clear, Mr. McCarthy, do you have any expert witnesses that we'll be able to address this afternoon?
I do not. I mean, if this is an issue, I could try to contact Dr. Rios Tovar, but my other two for sure are for tomorrow, and Rios Tovar was supposed to be for tomorrow. So, and I mean, I don't know for sure. I can't say. My feeling was that this particular expert witness being offered this afternoon, we took maybe at least 90 minutes or more, I don't know, with Dr. Monson, who, frankly, although I made my objections, he was straightforward individually, and your Honor made the correct decision and all of that, right? This is going to be a little different, I think, and I think this fellow could go a little longer.
Okay, no, that's fine. I just want to kind of map it out. So we'll do that. We'll start back up again at 1:30, and then we'll do the state, excuse me, the defendant's second expert, and then tomorrow morning, and I need to check and see if we need another Zoom hearing or if we can use this one. I don't know. I'll check with Robert, but we're scheduled to start at 9 o'clock again tomorrow morning. So I assume then we can do the experts that you will have available to us. I mean, I don't see us doing it all day, but maybe you do. I don't know. Y'all,
I hope not.
I don't think so. I mean, I don't know who you have. A lot of these individuals, well, Dr. Morsi, I know for sure, Dr. Denovich, I mean, have been testifying at the courthouse for the last 20 plus years. So I don't know. But at any rate, so I'm assuming that's probably going to take the morning. I don't know if we'll be able, if we need to go into the afternoon, but if we do, I have that time available.
Perfect. Thank you, Judge.
All right. And with that, we're adjourned until 1:30 this afternoon.
All right.
Judge,
Thank
Judge, this is Robert.
Yes.
The afternoon hearing will be another Zoom link, and
Okay.
tomorrow's will be another Zoom link.
Okay, terrific. Thank you so much. And I know you'll provide that to us in time for us to jump onto all of that. So anyway, but good job, everybody. I appreciate it. Thank you.
Thank you.
Okay, bye-bye.
Thank you, Your Honor.